Hello and welcome to this virtual panel brought to you by CTC Legal Media. If you're new to our channel, please don't forget to hit the like and subscribe buttons to hear more from us in the future. The topic of this discussion will be the impact of AI on the IP industry, or more specifically, navigating the AI revolution in global IP. This panel consists of 4 incredibly distinguished professionals. Our host today is Relani Belous, founder of the Belous Law Corporation and the Trademark channel. And she's joined by our panelists, Leah Stevenson, Senior Counsel of Entertainment and Digital Media at MGL, Arifa Kokab, Scientific Founder, Chief Neuromarketing Scientist and AI Engineer, and Iris Jackson, Founding Partner of Entertainment Lawyers for Los Angeles, also known as Ella. From the argument of AI efficiency over reliability to how the next generation of IP lawyers treat AI, or what kind of specialist training may be needed in a shared future between AI and IP, or the risks around digital identities and deepfakes. This discussion aims to shine a light on the biggest questions that need to be asked in the IP, entertainment and AI industries. Please feel free to join the discussion and leave comments or questions below. We hope you enjoy this video.
And just to start out, I'm Relani. I'm in Los Angeles. I'm guess what, an IP lawyer. And I work in the media and tech space. I run my own law firm, working with tech and media clients and small medium-sized businesses, helping them navigate their brands in the age of trying to be a 10x a lawyer as well. I'm going to introduce the panel in a moment, but also just want to give you an overview of where we are, or where we think we are. We're in a moment where AI is definitely out there. I checked before we started this. In 2020, .ai, which is actually Anguilla, the domain, the GTLD. And in 2020, there were only 107,000 registrants for that domain, .ai. And now we just, this week, hit over 1 million registrants for .ai. So it's definitely something that people want. And we look at that from a branding standpoint. We're sort of at a moment where AI tools are evolving, faster than the rules govern, and that creates a real risk for businesses moving too quickly, because everyone it's sort of a race to be first to be there, and platforms like Sora are powerful, but as they're developing, when you build it something that's something not fully settled, as we saw, you inherit legal ownership and compliance issues you don't plan for, which is something that Disney saw. Especially when the platform itself, is not even around as long as your business. And we see that also using web development and things that we're using, sites are using these AI tools, and they may not be around to support them, like, the old fashioned, WordPress, which you can rely on. It's been around for a long time. And so, you look at Disney and emerging AI use cases and see how quickly things can get complicated. And so today, we're going to break down those risks in different industries, in contracts, and web development, and content ownership. And so you can move fast and, as lawyers say, carefully. So I'm going to let the panel introduce themselves. Let's start with you, Leah, and tell us a little bit about yourself, and then we'll move on.
Absolutely. My name is Leah Stevenson. I am a senior counsel at MGL here in LA. I am over the entertainment department, and I mostly represent talent within the IP, entertainment, and business spaces, often negotiating their contracts with labels, music distributors, production companies, and assisting with their copyrights, trademarks, kind of being a full-stop shop for creators and talent within the entertainment industry interested in protecting their IP, as well as, maybe forming or maintaining their entities as well. So I'm really excited to speak about AI and just the advancements that are occurring, the legal considerations from, the perspective that we see right now, and kind of where we see it going, even though we can't really anticipate exactly where we're going with AI.
Okay, great, great. Arifa?
Hi everyone, my name is Arifa Kokab. I am a biomedical neuroscientist as well as an applied AI engineer, and I'm also the founder of the Neurobusiness Corporation, which is a global applied neuroscience AI engineering company. Now, I build a lot of AI models from scratch, and I'm here today to talk about AI from the inside. So it's an absolute privilege to be here amongst such amazing women. Thank you.
That's good. We can always use a non-lawyer. And Iris?
Liz Jackson, and I'm the founding partner of Entertainment Lawyers of Los Angeles, or ELLA. And it's a boutique law firm in LA that focuses on talent representation, production, business, and legal affairs, and outside counsel for entertainment companies. We do indie films, documentaries, and television work with production companies and studios on a variety of projects. But right now, focus of my practice is helping creators, talent, and production companies navigate AI in entertainment. And I'm very excited to be here on the panel today.
No, well, welcome everyone. Thanks for joining. So let's go on. Let's do lightning round one, which is let's talk a little bit about efficiency and reliability, and kind of as I intimated at the beginning, we've moved past sort of experimental phase of AI. I think we go to panels and here it's coming, and it's here. It's here, and it's now also embedded in a lot of daily workflows. I think we see that, when we call up places, we know we're not speaking to a human, or you're dealing with a bot, or you're seeing that in cases where people are citing the wrong cases, or cases that don't even exist. As they say, hallucinations used to be something that was beneficial from maybe something other recreational activity, but now it's a bad thing. So, but speed does come at a cost. And so, Leah, maybe let's talk a little bit about that, from a digital media perspective. I mean, how are you balancing that, especially, we see that with a lot of celebrities going, and trying to do these non-traditional trademarks too. What's, what are you doing in the massive, reduction of time for drafting, for some of this, there's some new laws in California too on AI and what needs to be in some of these talent agreements, and for drafting against, how do you balance the speed versus getting it right and presenting that to the client?
Absolutely. I think, there's great AI tools that law firms are using or integrating into their everyday practices to make their workflow more efficient. However, there's some AI tools that I wouldn't use. For instance, there's a great tool, Counsel on Westlaw is an AI tool, right? It helps you be able to draft and do research much quicker versus perhaps some lawyers going to ChatGPT to completely draft their pleadings or their motions to the court. As you said, there's been a lot of hallucinations, especially with AI in the terms of these cases that don't exist. And they are citing cases. People are not using, not reviewing it with their human touch, and then submitting these documents to the court, and the court is sanctioning them, right? So I think there's a way to make AI efficient and help with that efficiency in the workflow. But I think there's always needs to be that human review, that kind of almost as if you were supervising a junior attorney. You need to be reviewing the work product that's coming from there, whether it's research, whether it's an assistance with drafting, you need to be reviewing that. So even though AI can be leaned on to make workflow more efficient and to be able to get more matters done in a day, you don't want to heavily rely on certain AI tools that are not closed circuit in that sense, maybe like the Counsel on Westlaw, because you don't know where that, some of that information don't even know where it's coming from. Apart from case citations, there's also drafting. I know I've encountered, I'm sure you guys have as well, where people are bringing contracts to you and saying, hey, can you just kind of look at this and tweak it for me? And the first question I have is this from chat? Because I can tell. it hasn't caught up yet, and I'm sure it will get better as it continues to learn and see other contracts. But right now, it's
Right.
not sufficient. It looks like, a free template online or worse.
Yeah.
So I think where you can utilize those AI tools in practice to make a law firm or your legal practice more efficient, that's great. But there's definitely pitfalls and express liabilities for lawyers to be utilizing AI or relying on chat for their legal work product, and that's
Yeah.
your license on the line, and so that's not something I would ever want to jeopardize. So I always make sure that I'm reviewing anything. I don't use AI that heavily within my legal practice, but if I do,
Right.
it's for research aspect, and I'm still drafting on my own, still coming up with the creative legal arguments and factual allegations on my own. I'm just utilizing that as a potential tool to
Right.
make the workflow
I
more
gotcha.
efficient.
So let me ask, so Arifa, from your standpoint, obviously you're an engineer and developer, and what do you think from the standpoint of what you're seeing, in various industries? What is training that from a lawyer standpoint that IP professionals are missing? Is it general purpose AI enough for accuracy, or is there something that needs to probably be developed that's more accurate or more bespoke to law? Because I think what we're also seeing, and I've read about this, is that AI knows when you're testing it and it'll give you the answer you want, and I think that's really not something that's really overtly discussed, but they test these models and they do they're doing it to fool people, and then obviously what Leah's saying, right, you end up with a bad result. So what, from an engineering standpoint or development, what do you think needs to happen from a professional standpoint?
Well, first of all, that is a great question. I think before I get into specifics, I just want to quickly go over what AI truly is. So an AI model is basically a computer program that is trained on massive amounts of data. And a large language model is basically trained on general data, and its main job is to predict in terms of language what the next word might be. And
Right.
imagine it being like a storyteller, and this is the main reason why hallucinations happened, and that's why I wanted to start with this, is because the LLM's job is to complete the story, whether or not that case or information exists. It needs to do its job, and it's been made and trained to complete that task. And the whole reason why general purpose AI like ChatGPT or Claude is not suitable for particular law use, especially for IP firms. Now, having said that, yes, there are certain skills that lawyers, I believe, now, or IP specialists now need to start to adopt in terms of AI literacy. I'm not saying learning how to code, rather to really understand what has this AI been trained on. Because if you don't understand the basics, it's going to end up, and you start using general LLMs like ChatGPT, how Leah mentioned, it's going to start creating things on its own. And so yes, to answer your question, general purpose AI is not suitable for use in IP law. If that answers the question.
Yeah, no, I get it. I think, and also, what's being prompted versus you having to think about, hey, okay, I have this general idea and then I'm going to, break it down. I think part of that is, what we're talking about. And so, I mean, Leah, I mean, you kind of intimated this. I mean, what do you think from a junior associate level? What would you, I mean, if you're working with, junior lawyers, I mean, what are you looking for? Are you looking for a red flag that somebody did this in 5 minutes versus it should have taken, maybe an hour and a half? Or, I mean, what, are you looking for red flags, or when you, like, what do you, I mean, or are you seeing that when you negotiate with other sides and you're seeing the work product?
So the junior associate that I actually supervise, she doesn't use, and if she does, I haven't caught it. She doesn't use it in her work product. I've more so caught it when maybe potential clients are coming to our firm and they want to see how much we would be charging to review an agreement. Most of the time it's when these parties are they have a, legal budget or legal, budget constraints. And so they're just trying to
Right.
see, hey, we have a document. Can you just quickly revise it? And it's not always that simple, right? Like your document may be lacking major substantive provisions that we would want to almost redraft this, or perhaps the template that you're bringing to us is really not sufficient for what you're trying to do. You're bringing me an independent contractor agreement, but based on our conversation, you actually need an employment agreement. So the language is going to look completely different. And yes, chat may have been able to spit something out for you and give you this document to work from, but it may not be sufficient for your legal needs at that time. And so there's other AI tools that obviously people are utilizing to enter into these, long form agreements. But as a legal counsel to anyone, I would definitely make sure that I'm reviewing the provisions, adding in substantive sections that need to be there, and making sure that any language that is perhaps not applicable is removed. So I think that's where I'm kind of seeing AI at play.
Okay. Yeah. And I did forget to mention this at the beginning. There is a disclaimer. These are our opinions. This isn't legal advice, and you should get your own lawyer. So this is mainly just a discussion. So just everybody keep that in mind. Let's kind of, move on and talk a little bit about, the human touch, which is interesting that we have to kind of bring in the fact that now the human touch is secondary, not primary. There is a person behind every prompt. I think, the Copyright Office has sort of discussed that in their, 3-part paper about human intervention. But, but the nature of that person is changing, right? Whether now it's who is that prompt and what's behind that. So Iris, let's talk a little bit about that. You've always, so you've championed obviously for the human element in entertainment law. I mean, that's what sells a movie. That's what people go to see. They want to see, Zac Efron take his shirt off, or and other ones keep their shirts on. I guess if AI can handle some of the heavy lifting of the contract portion, what happens to the content in those contracts, number one, and then two, what happens to the next generation of lawyers that are coming up, that you may be negotiating against, in how they learn how to, how we all had to do the sort of grunt work, and now that's sort of a, I wouldn't say it's a free ticket, but it's sort of, earning your keep and learning, the hard way of having to read through documents and those kinds of things. So maybe talk a little bit about, about that.
Yeah, I mean, I think almost always when we talk about AI, the conversation is always around like, where is there going to be the job loss? And I think that really is most prevalent in sort of those entry-level junior positions. But the secret was that the grunt work was never really grunt work, right? That was where you learned how to do the job. That's where when you marked up an agreement, whether that be like writer, actor, whatever, when it came to production, you weren't just filling time, you were learning what to negotiate, what to fill in. And so, in 5 to 10 years, okay, yes, cost efficiency, we're able to have less junior associates help us out at the beginning, but in 5 to 10 years, we won't have any mid-level executives ready to take on more responsibility if they didn't kind of do that work when it started. So learning how a deal is structured, where the leverage lies, what a bad clause can actually cost somebody, you only really get that sort of from repetition, that pattern recognition. So yes, AI can compress that process, but we have to be intentional about creating other pathways for junior lawyers to build, up and that same instinct. Otherwise, we're just graduating people who can review AI, but can't catch what it missed.
Yeah, I agree. I mean, I think, look, I mean, AI is doing what a lot of lawyers do, right? Taking massive amounts of information and channeling it into something that is, workable. But Leah, what do you think? I mean, how do you ensure the human touch doesn't become the human editor? and so that, you're servicing the clients, but you're also not disservicing the client by saying, all right, it's not necessarily like, I mean, it's the difference between, fast food and fine dining, right? I mean, you're still eating, but it's not the same experience of doing it, a certain way.
Absolutely. I think one way of looking at it is making sure that you are not so heavily relying on AI that it's basically AI doing the heavy lifting, right? It should be assisting you, making your life more efficient, making your workflow more efficient, but you should not be heavily relying on AI to the point where, again, you're not reviewing your own work product. You're saying, okay, I don't know how to draft this at all, and just being okay with whatever comes out of it. It does not help you or your client. And then realistically, for me, another reason why I don't heavily rely on AI, other than where we have automated tools or things to make the legal workflow or billing
Right.
easier, I think you also become dependent and reliant. In even a personal sense, there's people that I know, I don't know them personally, but I've heard, right, that they run to ChatGPT when they need to text their friends or when they're interacting with somebody on a romantic connection, but then perhaps they get on a date and they're not having the same type of conversation because they
Right.
did not they did
Right.
not write that stuff. They did not come up with those, discussion points, that conversation point. And it's the same in law, right? If you are so heavily relying on AI, at a certain point, the things that you're working on, you don't even understand them. You don't know them. You don't know the legal aspects, the considerations. So how are you able to properly advise your clients if you yourself do not understand, as the legal counsel, the true implications, the legal considerations, the risks, the liabilities, and the flags? That's what we go to law school for. And so I completely agree with Iris that if you start to remove that, the junior associates and replace it with AI, you're now just gonna, you're not allowing them to learn and grow. And that grunt work is actually how they get to a more senior position, by learning and doing. And if you have AI doing all of the action for you, you're never truly going to learn.
Well, right. And I think a lot of it is, some of these are closed networks and, they're whatever. But Arifa, let's talk about it from the brain, because that you have a very intimate relationship with the brain. So, I mean, can AI really, I mean, again, I think, a lot of us, have been working a while and we have a historical context. I mean, can AI really ever replicate intent or nuances? For example, like looking at arguing a trademark case or arguing, like some of this work they do with, they know what goes on a film set, and there's things that just are not, they're more ethereal, and they're not, they're based on the human experience or based on, what, I know when I deal with this producer, they're going to pull this kind of stuff. And I mean, AI doesn't really know that, because that's not, that's not its job. So, I mean, can it ever really do that? Or, I mean, is that something that it's just never gonna, it's never really going to get there? Or, I mean, and how do you integrate that into, an analysis of, like you said, doing legal work?
Right. First of all, great question. To answer your question in one sentence, it cannot. And I'm going to go into detail, but the reason why it cannot is because it will always have a mathematical output. Now, in order to understand from an intent perspective, there's something called theory of mind, which is localized to the temporal parietal junction, as well as the medial prefrontal cortex. And these two areas, when they work hand in hand, they help us humans to basically intuitively infer the thoughts and the beliefs and basically deception of the other person. And these are like nonverbal cues, even. So AI doesn't have the power to integrate that, number one. And a great example of seeing the theory of mind in action is like, imagine when an IP lawyer, for example, if there's a trademark confusion case and there are two trademarks that are similar, the IP lawyer for the plaintiff is possibly going to be stepping into the defendant's brain and trying to narrate the potential what they might have thought to prove bad faith. And AI just doesn't have the power to think like that, to step into another person's shoes. And this is where the human factor is key. Now, the second thing is nuance. Now, in terms of nuance, neuroscientists actually executed a study using fMRI, functional MRIs, where they would show a person two probably like similar logos, and the results were they saw that if they're similar enough, the amount of neuronal activity in the brain actually decreases. And the reason for that is because the brain automatically recognizes this as, let's say brand number one, brand number two is trying to copy brand number one. They will automatically think it's brand number one. They don't think too much, and then they will just go ahead and either purchase the brand, thus, taking advantage of brand number one's reputation, right? So that nuance is something that AI cannot replicate. And will it ever be able to replicate? In my opinion, I don't think so, because this is a biological hardware that is only in humans. And it allows us to, like, for example, if I'm talking to you and I can tell whether you want to continue talking to me, and these like nonverbal cues, AI doesn't have the power. At the end of the day, it's just a computer program with mathematical tools or outputs. And like Leah said, it can assist you, but it definitely cannot. No, it will never be able to.
No, you're right. I get it.
Yeah.
All right. Well, thanks. I'm gonna shift gears a little bit, because I think, you talk about, tech and media and things like that. And I think this will dovetail into that is, what we've seen from the entertainment business. And I think, maybe we'll go into this a little bit is, I'm not sure if entertainment really does not like technology, but they are very reluctant to new changes. And we saw that going way back to the, the Betamax case, when that first came out, and music versus the file sharing, which we saw in Napster in the early 2000s, where they weren't against digital music, but they were against losing control of that music. Then you had, the streaming issues where, Blockbuster, I think, sort of was like, whatever with Netflix. And then Netflix sort of, essentially took that over. You had that also with, the TVs and similar to Betamax, the DVR issue, which if any of us remember TiVo and the TiVo panic. And, Leah, I think also you guys do gaming there. So gaming versus user mods and streamings, how to shut down the mods and the fan content. And now, modern day, what we're talking about it is Hollywood, versus AI. I think we've hit, just in the content, and most of them relate to media, is, over 100 cases on AI. And then, I think, it's sort of like, there's the 4 stages of death. It's like the 4 stages of AI, or technology, where, media does this, the first thing is they ignore it and say, oh, this is just a fad, or they fight it and they have lawsuits. Then eventually they adapt it, and then, they may build their own version, right? So I think you have those stages. So Iris, I think mid-sized firms are more at risk now, I think, from adapting some of the AI things in context. And I talk about it in entertainment because I know 2 of you work in entertainment too. But I think the bigger firms are going to probably adapt, and some of the bigger media companies too, and law, and I'm just bringing that parallel. But I think what we're going to maybe see is, a smaller firm, is able to adapt AI because, they have a lower, committee level and able to adapt that. But I think let's talk a little bit about that from an entertainment perspective, but also, what's the legal risk? Because you're going to see, these mid-sized firms, probably struggle with some of this. And so
oh, sorry.
Go ahead.
The mid-sized firms are sort of at that struggle point, right? Because the larger firms are going to have more resources to put into building AI into their infrastructure and figuring out how to incorporate that. And like you said, solo practitioners or small boutique firms, they're quick enough to adapt and they don't quite carry the same overhead that a mid-sized firm is going to have. And so they're always, I think the mid-sized firms are going to have struggle, with having the capital to invest the same way big law firms are. But sort of like a legal risk aspect, I would say that, ignoring AI doesn't necessarily create like a liability issue for those firms, but it does create like a competitive and ethical risk, because if your competitors are doing more through contract analysis, faster rights clearances, more comprehensive IP searches, and you're not, then at some point that gap starts to look more like a failure to competently serve your client. So I think that's where it kind of gets uncomfortable from that professional responsibility standpoint. And I think that's really where the gap is going to become most clear for those mid-sized firms.
Yeah, look, I mean, it's a tool, and if you're not using it, it's like saying you write all your contracts by hand. That's not probably, viable. So Leah, from an entertainment company perspective, you have these entertainment companies now using AI, and that we started out with sort of, Disney finally gave in, and then they got sort of, I won't say gaslit, but sort of like that sort of went by the wayside. They're using that to analyze their IP catalog. And so what do you think is the implication for a studio when they start to, use AI, and what's the mess in IP when it uses its own DNA sort of to generate new content, right? Because I mean, all these, there's so many restrictions on images and things like that, which you draft, and everybody has approvals, or how you do that, and you have guilds. And so, I mean, what do you think the risk is in doing that, right? Because I mean, you used to walk in and an executive had like 400 scripts in there, and they're like, okay, let's remake this because we can't think of anything this week. But maybe talk a little bit about that.
Absolutely. I think where it starts is like, okay, we own this IP, this IP, right? Whatever we own, whether that be the actual, film itself or the script, anything, right? We own that, but then we're using AI to create new works from our own IP. The question then becomes, who owns that IP? Are we looking at the terms of service, EULAs on these different websites to see? I know that some, AI websites or tools, sometimes that terms of service says that the company owns it, right? I know even with like editing apps, sometimes they say that now they own that content. You may have created it on here, and this may have been your original concept. You put this together, you think this is your IP, but the terms of service can say something very different. So I think the problem becomes is we're using our own IP. We're then putting that into an AI tool to try to create some type of new content at a faster rate than maybe us using writers or us using actual, staff to help us create content based on our IP. But the question now becomes, do we actually own this new work, or is it a derivative work, or is it owned by the actual AI tool that we put it in? And that could be problematic because obviously these production companies want the full rights to whatever content they have, whatever film or script they have, so that they can exploit those rights, license it out to third parties, things of that nature. So when trying to be efficient or faster and trying to make sure that you are integrating AI into your company, becomes something that could be a detriment to your company, I think that's where it could be a consideration that production companies need to look into. And I'm sure they're looking at the terms of service. I'm sure they're talking to their, general counsel, their outside counsel about the implications of using their own content within these AI tools and what does that mean. But I think when we're trying to be efficient and we're trying to stay ahead of the game, we also have to be mindful that since we don't know where this is going, we don't know all the legal considerations, we need to be mindful, especially when it's regarding ownership or our own IP rights.
Okay. So, Arifa, from a technical standpoint, is the barrier to entry going to be too high for firms that don't have a dedicated strategy at this point? Or, I mean, is there still hope? Or, I mean, if you were advising, sort of a professional, I always see lawyers are high on the AI list for conversion. I mean, is there a barrier to, is there a big barrier to entry for them, or what, what is that? Maybe talk a little bit about that.
I think from a technological perspective, the technical barrier is not as high. And I think the main question isn't really, is the technical barrier high? I think the true question is their AI strategy. So to adopt AI is not as difficult as it was 5 years ago. So it's easier to bring into the company. The hard part is to actually work with it, work with these tools, understand these tools. And I think this is where this is where law firms, if they don't integrate the AI in a correct way, in a strategic way, they're going to miss out. And I say this for example, for law firms or IP firms that, bill per hour for different services. AI can do the same thing at much, well, let's say a cheaper rate and faster as well. However, the question is not going against AI. I think I'm not a law professional. However, I think the main thing should be to strategize and bringing in the human touch, because that's what AI cannot do, and to really work with it hand in hand. And that's what I mean when I say AI strategy. So it's not really just, hey, let's bring in these AI tools into the company. Rather, it's like, okay, well, if we've got these AI tools, then how are we going to really utilize them in the correct way? And another thing I would like to mention is that, for example, for IP firms, you can't just feed information in general purpose AI like the ChatGPT, because it's then essentially that IP is not being protected, if that makes sense, because these general purpose AIs are consistently training the base model. So you are releasing client sensitive data. And this is where, which ties in with my first answer, yes, law firms need bespoke AI systems within their companies. I think now to be more competitive in the market, because there's so many AI tools now, for example, to track different things that clients can potentially turn to. And if you want to be competitive and stay active in the market, in my opinion, you're going to have to learn to work with AI. So that means educating all your lawyers and getting them AI literate, and getting them different skill sets with regards to AI. The data moats. This is where the company basically trains their own AI on.
That's what
So there's different architectures. The way LLM models are made from an architectural perspective, its main job is to predict what the next word is going to be. When I talk about an AI system built for a company, it uses a completely different architecture, and it may talk in the same way like an LLM. However, it uses something called RAG. RAG is Retrieval Augmented Generative Model, and this just takes information from whatever you give it. It doesn't go outside. So whatever you build within it, it stays in that circle. I think that's key. And building that's the main thing. So I guess strategy is more important. Everyone can have access to AI now. The tools are not hard to access. So the technological barrier is not as high, but from a strategy standpoint, that's where I think many people are going to be facing issues in this sector.
I agree. I think just integrating that. Let's shift gears a little bit here and talk about social media, which everyone is on, and digital identity, and again, we've had AI influencers for a while. There was one that's been around for a while, but I think we're seeing the sophistication and the level is really amazing. Some of the things that we've seen, especially hyper realistic deep fakes. I mean, Leah, let's talk a little bit. I mean, I know there are some changes in California on how AI is being used and how it has to be disclosed in contracts now, but how are you structuring the talent agreements to to avoid, harvesting, or even are you putting clauses in that you can't use materials for learning, or how are you doing that specifically for contract terms?
Of course, it's crazy how a year can change the way you're,
Right.
revising and reviewing contracts. We're definitely adding those clauses in, especially for those brand partnership deals, to ensure that they're not being able to use the creator's name, image, and likeness or publicity rights for AI use at all. I'm also seeing it in music, where music distribution companies or record labels, where maybe they have artists that are signed, which are clients, they're now perhaps proposing AI use. And so they're, trying to amend that contract or provide some type of proposal, or it's even included in the actual long form agreement now where they may have that use. And so if somebody is not using counsel to review this agreement and they just sign it, or perhaps their counsel doesn't even really care, understand the implications of what that could mean, unfettered use of AI with
Right.
regards to this client's NIL rights. I think that's the problematic point. So we're definitely adding that language into those brand partnership deals, content creator agreements as well, but also looking out for it in other industries, because people are now including that the use of AI and, wanting to be able to replicate that content, or replicate the actual creator's publicity rights. And not everybody is open to that. Sometimes they're offering a little bit more compensation for such use, but other times it's just kind of snuck into the contract. And if you weren't really reviewing the entire thing and you think this is some type of template form, you're going to
Yeah,
miss
you're
that
right.
language.
So Arifa, I mean, we used to have like handwriting experts, and so in the court, in courts, I mean, or even, again, we're going to probably start to see expert witnesses in AI as things progress. I mean, is there a digital watermark or other, forensic type of solution that you think would hold up in court to show, hey, this is fake or this wasn't authorized? I mean, there was digital watermarks way back when, and that was used more for, not for so much ripping things off, but to be accountable, to know that that was a copy of something and that, you were owed royalties on that. I mean, but now, how, from a standpoint of, testimony in court, or visual things, or, someone's faking a voice on a call. I mean, is there a digital way to do that, or for something to hold up in court to prove that something, like a deep fake is a deep fake, or anything like that?
Well, we can approach this in two different ways, in two different ways from a forensic approach. The first way is to use AI classifiers to basically that will be able to detect from the metadata, the way the person is, say, blinking, and the more visual things. But I cannot say that it would be like 100%. Like, there's no silver bullet. It's not going to be like, okay, yeah, that's
Right.
definitely okay. That's not there. However, I think this brings me to the second one, which is provenance-based watermarkings, which I think should be adopted, which basically means that it is watermarked at the time of production, and it's able to then be tracked back to its roots. And this would be going forward. So I think this is where regulation needs to, adopt. Like,
Yeah.
ultimately, companies need to adopt. Like, I believe Adobe has already adopted it, and Microsoft, Google, they've already adopted it as well. And I guess to answer your question, not really. There's not
Yeah.
really like one hardcore thing. Yes, in terms of the AI classifiers, they can detect anomalies, and those anomalies can be used as supporting evidence, but not as
Yeah.
concrete, like, okay, yes, this is definitely.
Yeah, and I think that's part of it too, and I've read about this too, where people are, hiring AI agents. They're doing that. They're booking their vacation, and these AI agents are agreeing to terms and conditions. Maybe things aren't refundable or this kind of thing, and based on the Electronic Signature Act, you might be responsible for what they do. So I think there's a lot of things, especially privacy policies. And Iris, I mean, from your standpoint, let's maybe with celebrities, I mean, who owns, like, we see McConaughey tried to kind of, a lot of these celebrities are I think upset for various reasons. That is their brand. They have a style, I think they have a certain vibe. I mean, we saw that in, a lot of the early music cases where people sounded like Bette Midler or something like that. But I mean, something that is questionable, or what's the vibe of an AI influencer that really mimics a celebrity? I mean, who owns that? I mean, what do you think about that?
Yeah, so we, in the court of law right now, that's sort of the core problem, is who does own that. So we sort of have solid ground on the right of publicity for name of likeness, and California, the problem is we are state by state here in the US.
Right.
So like California is moving in the right direction. They have legislation like AB 2602, but like what specifically addresses digital replicas and requires consent before a person's voice or likeness can be reproduced. We do have the No Fakes Act that's being pushed at more of a federal level, but that's not done yet. And so the vibe, like the vocal cadence, the aesthetic, the personality signature, that still lives in sort of a legal gray zone. And we're stretching existing trademark and unfair competition to doctrines to cover that. And it works, but it's a little bit like putting duct tape over a gap that has, like a bigger issue. So like, what makes this particularly urgent for talent and their representatives is that, by the time mimicking that person is obvious enough to litigate, that damage is already done. And audiences will form this sort of parasocial relationship with something that was never real, and the person loses control of their identity in the market. So I do try to advise like clients to get ahead of this contractually. I think that's kind of the best way in like their brand deals or platform agreements, or in any agreement where their image or voice is being captured, because waiting for the law to fully catch up is not really viable. So, but the court of public opinion is clearer. People know when they're being mimicked, and we're just kind of waiting for the law to catch up to that.
All right, let's kind of move on. Lightning round, last lightning round. Here's the IP law that's you sort of intimated that, where what's the law, affecting AI development. So Arifa, recent legislation, you have some transparency acts coming through about AI, changing the way you actually weight and build the models. I mean, unfortunately, a lot of this is unregulated. You regulate food, and these are products that consumers are using. We have that for the food we eat, and drugs that we take, and this is a product that obviously is a material item that's not really overtly regulated at this point. And also, I've seen things where maybe some of the developers might be held liable for some of the elements of these things. So are the engineers, do you think engineers are being forced to be more creative, as they say, because of legal constraints, or do they even think about that, or they just, everybody's in a...
Yeah, well, that's actually a really, really, I guess, a developing sort of a situation. But yes, it is definitely forcing AI engineers and developers to get a little bit creative with their innovation. But in terms of the Transparency Act, it basically tells, or it basically wants everyone to know what is happening at each stage of the AI model. So each stage of the process, from the data extraction to the different levels, say if it's a convolution neural network, to the output. So it's not like a black box.
Yeah.
And this in AI we call explainability AI, or explainable AI, or XAI. So it's definitely pushing all engineers to document each step of the way, which I think is amazing. Now, in my company, I had anticipated this to happen, and I had already started doing explainable AI at each level. Now, in terms of data, for example, for me, I just use myself as an example. I take data with consent. Now, in the past, what AI engineers would do is they would just scrape the internet to get like data, and then they would build, models out of it. That's not allowed anymore. But yes, it is definitely forcing them to become more mindful, more ethical, and to basically disclose if a non-technical person were to see the code, they're supposed to show and identify at this level of code, this is what's happening. At this section, this is what's happening. That's what explainable AI means. And that's the whole idea of the Transparency Act. And if an AI company were to be audited, now how often would they get audited? That's another question, a different topic. But in terms of regulations, if they were to get audited and that explainability AI is not present, then they can face penalties.
Okay. So let's talk a little bit, Leah and Iris. I mean, you can each go and answer. I mean, what do you think is, like what she's saying, what is a hidden aspect of AI that you think isn't being protected yet that should?
I think from my perspective, it's going to be that performance layer, like we were talking about just a little bit earlier. So often when we talk about AI, we're really talking about the output, right? We're talking about the generated image or the synthesized voice or the AI script. But there's a whole layer of human creative contribution that fed those models that's kind of being laundered out of the conversation. And like I said, we've made progress with California legislation, or SAG has negotiated protections with studios and AI companies, and those are, good wins, but they're union contracts that don't protect everybody. So they don't extend to every performer, and it doesn't reach back. So if you already remove the labor unions entirely for someone like influencers, there's very few protections for them, and it's still a little bit of like the Wild West. So really, when I say performance, I mean like the content that's been fed to the AI training miles that it's already ingested, and those choices that an actor makes that are hard to, have AI replicate, which is sort of that human touch. So that's the conversation I think we should be having right now, is sort of the harm that's already happened. And trying to, again, get ahead of that at more of a contractual level is something that people can do now to protect themselves. But I would say that's sort of what I would say.
Okay. Leah?
I would agree with Iris on that. I think it's the input. I think it's with the people that are perhaps, if we're using AI and we're in, the writer's room, and we're feeding, we're not using just the writers anymore. We're feeding their concepts, their ideas into these AI tools. Obviously, ideas are not protectable themselves. But what if they've come up with a very substantive, developed, kind of mock script in a way, or some type of skeleton draft of what they want, and they're just looking for AI to tweak it? Now, what is protected? The reason that AI was even able to come up with such a substantive answer in the output is because of what that human put into AI for it to develop that information. So if we're not protecting the input, then, as someone who's a creative, if I were them, I'd be a bit fearful of putting my own ideas, my concepts, my thoughts, even though those are not copyright protected, but I'd be very nervous to put in even a skeleton draft of what I'm looking to work on. What if I have a book idea or something to that effect, and I just want you to kind of tweak it and rewrite it, or a social media post or something? If I don't own that input, I may just have to do it myself and do it the old fashioned way, rather than have you tweak it and now say that it's yours.
Yeah, no, I mean, look, I think, I agree. I think it's something in development. You don't really know where it's going. I come from a generation where you didn't even tell people your last name, or your phone number, and, or don't talk to strangers, or don't get into strange cars, which we do now all the time in Uber, and cars that have no driver. So I think it's definitely, and how we relate to people, as humans. So unfortunately we're getting the music starting to play. We're getting towards the end. So I want to thank everyone first for being here, the wonderful ladies panel here. And so let's finish this off and continue the lightning round theme, and maybe give me one sentence which you think is the most important skill that an IP professional should have in 2026 and beyond. Let's start with you, Leah.
I think it would just be knowing the actual law and the basics, knowing the law and the business, because even if you are going to utilize AI, you having that knowledge is the basic, right? And then being able to use AI to your advantage to understand it. If you don't have the basic foundation, you're not going to even understand what AI is feeding back to you to know if it's right, wrong, in the right direction or not. So I think having the foundational basis in law and in business is so important. And that's something that's always been preached to us. But I think now that AI is on the uprise, people are sometimes forgetting that that foundation is so imperative, even when putting information into those AI tools.
Okay, nice. Arifa?
For me, I would say the most critical skill would be algorithmic intuition, which is basically the neurocognitive ability to bridge that gap that I was mentioning earlier between the human legal attempt and the AI generated output, and all while maintaining that rigorous human in the loop, audit for technical accuracy and ethical data provenance.
And Iris?
I would say not losing sight of the human touch, whether that's with your clients and their human touch that they add to it, or whether, again, it's the human touch that Leah was speaking to, that we as professionals spend a lot of time practicing and learning and getting right. So just focusing on the human touch while still using AI.
Yeah, and I think for me, again, you talk about, I think AI is not the Midas touch. It is, it is about the human touch here. And I think all of us, understand that. But I also think that's why we bring people together, because it is important, because we all understand different things. And I think, we work on the law, but, like Arifa works on the brain, which affects all the things we do daily, and those kinds of things. And I think it's important to understand, these platforms, because you really, you do need to, I think, you didn't, as a lawyer, you didn't need to understand how the paper was made that you're using to print out on, but now you really need to understand what your systems are doing, because if you don't, I mean, that's going to be a problem, explaining, what did you do and how did you come up with this, and you can't point to an associate. What are you going to do? Point to a machine and say, "Oh, not my fault." So anyway, I'll leave it with I'll leave it with that, and hopefully there's humans watching us and learning something and maintaining the human touch. And I thank ladies, and I thank everyone at the Trademark Lawyer Magazine, and we're glad to be here, and thanks for tuning in. All right, take care. Bye-bye. All right.